Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning, everyone. You may turn on your videos and audio. Good afternoon, Council. Welcome to the 4th Court of Appeals. We are holding live arguments in our normally at our courtroom at the Cadena Reeves Justice Center in San Antonio. We welcome the advocates on this Zoom virtual platform, as well as the interested parties and general public viewing these proceedings on the court's YouTube channel. Please be aware that should we suffer any unforeseen technical difficulties, I will stop the clock if necessary and may temporarily suspend the proceedings. The judges will recess briefly, and our clerk of court, Mr. Michael Cruz, will provide you with further instructions and assistance as needed. We'll then resume the hearing, and counsel will proceed for the time that remains allotted to her or him. In light of the virtual nature of these proceedings, counsel, I wish to provide you some guidance to help you navigate through the panel's questions this afternoon. The justices have decided to raise their hand like so. When she wishes to ask a question, I may have to verbally interrupt you politely should your attention veer away too long from the screen to notice that a question is pending. At this time, beginning with counsel for appellants, I call for announcements in cause number 0419-318 CB, Benavides versus Alexander. Announcements, please.
Sean Reagan for the appellant in cross Benavides.
Judith Blakeway on behalf of the Guardian Appellee.
Again, good afternoon, and I understand we've blocked off time 20 minutes for the appellant, followed by 30 minutes for the appellee and 10 minutes for rebuttal for the appellants. You may proceed, Mr. Reagan.
May it please the court. There are 4 primary issues before the court today. The first issue is whether the trial court's declaration that Linda Alexander is entitled to possession and control of the funds in the disputed bank accounts was supported by the pleadings, and we argue that it is not, and that declaration should be reversed. The other issues more pertain to Alexander's appellate complaints, and we asked the court to, 1, affirm the trial court's finding that Alexander failed to prove that Carlos lacked capacity during the relevant time period, affirm the trial court's finding that Carlos Benavides made a gift of the O'Meara residence house to Letitia Benavides, and affirm the take nothing judgment on Alexander's tort claims for fraud and breach of fiduciary duty against Letitia. Turning to the first issue, and I think this is the quickest issue and the shortest issue, would be whether or not there's a pleading to support the declaratory relief awarded by the trial court in this case. As the court well knows, it started out as an interpleader case where the Texas Community Bank, Compass Bank, Merrill Lynch interpleaded funds into the registry of the court and said, you folks figure out who owns this money. That we got competing claims and the funds will be held in custodial legis until the court makes a further order. And that was what the jury was asked. Who made the contributions to the bank accounts? And the jury found 100% that it was Carlos Benavides. But the trial court went beyond that in its judgment. The trial court in its judgment entered a declaration that Alexander is entitled to possession and control of the funds. And that's problematic for a couple of reasons. First, there's no pleading to support this declaration. There's a declaratory relief. And that's the number 1 issue. But number 2, and more important, now we have essentially a conflict. We could have the possibility of conflicting judgments between what was entered in the 49th District Court and what may be entered in the guardianship court or the probate court later on. The issue of who's entitled to possession or control of those funds was a matter for the guardianship court. The district court in this case only had to determine who owned the funds, who made the contributions. So I entered a declaratory judgment going beyond the ownership issue the trial court erred. Number 2, by granting Alexander the right to possession and control of these funds and granted her the ability to change the right of the designation of survivorship, that interferes with Carlos Benavidez's purely personal right. As we mentioned in our brief, there's really no Texas case law to address whether a right of survivorship is a purely personal right. But in analogous situations, the Texas courts, including the Texas Supreme Court, has said like revocable trusts. A guardian cannot revoke a ward's revocable trust because that's a purely personal right. The Estates Code says a guardian cannot change or revoke a ward's will. And if you think about the impact or the effect of the right of survivorship, it is a wish or a desire by the ward before he was incapacitated to make a non-probate transfer of his assets, to go outside the probate. And so the right of survivorship, for all effective purposes in this situation, is no different from a will. And if it's no different from a will, the guardian should not be able to interfere and change his wishes after the fact. Number two, the second issue we'll talk about is the judgment's finding that Alexander failed to prove that Carlos lacked capacity during the relevant time period.
Counsel, before we move on to that question, the first issue that you have briefed is the question about the guardian's pleadings, right? And that the guardian didn't have pleadings on file. But I'm looking at Mathis's live answer and counterclaim that requested a final judgment decreeing essentially that Carlos would be the owner of all funds interpled by the financial institutions. Doesn't that get you there? And since you have really focused on your second argument, are you conceding that the pleadings support the request for declaratory relief?
There's no concession that the pleadings support the declaratory relief. Again, the issue in the interpleader was simply, and what was tried and what the jury was asked to answer and what the judgment should have said, who owns the funds? Anything beyond who owns the funds, i.e. possession and control of those funds, should have been a matter for the guardianship court. Now we have two different courts saying, Alexander, you have the right to have possession and control of those funds. So which court can enforce the judgment? There's conflicting, there's two courts that have issued judgments on this issue. Which one will be able to enforce that judgment? And that's the issue. And going back, yes, Your Honor.
Yeah, are you saying that the district court didn't have jurisdiction for the issues beyond what you've told us?
Yeah, that's a good question. I don't have any authority for that, but I would assert that the issue, whether or not the word or the guardian or Alexander is entitled to possession and control, is a matter for the guardianship court and the guardianship court alone. But we don't have to get to the jurisdictional question because there's no pleading to support the judgment that was awarded.
So let's assume that there are pleadings and that eventually Alexander, who took over as guardian, bottom line pled it through Mathis. What about the jurisdictional issue?
Assuming there's pleadings to support the finding, I would assert that the guardianship court should have the exclusive jurisdiction to determine whether or not its guardian has possession and control, the right to possession and control over guardianship property. I mean, I think that makes a lot of sense.
Thank you, sir.
Going to the capacity issue, I understand there's a complaint about what the judgment says, but essentially what the judgment says, in effect, is that Alexander didn't plead that Carlos lacked capacity during the relevant time period. There is nothing wrong with the inclusion of that in the judgment. Judgments are supposed to determine what the rights and liabilities of the parties, to dictate what was tried and what the relief was awarded by the parties. Summary judgments all the time dispose of issues, dispose of affirmative defenses. And in this case, what the trial court did is important for a couple of reasons. One, hopefully at some point in time, once we wade through all these appeals, there's going to be we hope to have a will contest. And we're going to put up Carlos's September 2011 will. They're going to argue that he didn't have capacity to do that. And what we want to argue at that point, well, you can't argue it again. You've already had a 3 to 4 week jury trial on this. We had 5 doctors testify. We had 12 jurors spend weeks of their time. This issue has been litigated. And number two, it actually was tried in this case. They put on evidence purporting to prove that Carlos lacked capacity as early as 2005. Dr. Tickner opined that Carlos lacked capacity in 2006 to 2007. So the practical issue here is they've already had their day in court on this issue. And if there's a second day in court down the road, we want to say, you've already had your day in court. We have the judgment. You failed to prove they lack capacity during the relevant time period. Now, is there a complaint about the wording of the judgment? Perhaps, but what the judgment really says is they failed to prove their incapacity defense during the relevant time period. And that's all that matters. And that is preclusive in a later trial if there is one. As to the merits of the capacity, there are two questions in this case. When was the gift made, and when were the valuable and permanent improvements made? You have to have both to have the gift here. In their reply brief, they say, Carlos, the evidence is undisputed that he made the gift in 2004. Therefore, anything that Carlos's capacity after 2004 is not relevant. In 2004, he's presumed to have capacity, and there's no evidence or allegation or argument that he lacked capacity in 2004. So the next question is, did he have capacity to acknowledge that she's making the valuable improvements, or did he consent to those improvements? And those improvements were made between January of 2011 and March of 2013. That's the relevant time period. And that's what the jury found. They found that he had knowledge or that he consented to those valuable improvements. And that's when the capacity, that's the issue they have. They had to show that he lacked capacity during that time frame. And the question that they submitted to the jury in the charge, the question they proposed, the question they asked for didn't include the dates of the gift or the dates of the improvement. So what we have essentially an omitted finding. So if there's an omitted finding about an essential element, i.e. the date of the valuable improvements, that omitted finding must be deemed in favor that supports the judgment. In this case, we have question one, said there's a gift, he had knowledge and consent. If there's a complaint about the lack of the date, they didn't object to it, and nor could they, it was their question. They didn't object to it, and they haven't raised an issue on appeal. So the date of the valuable improvements found by the court has to be deemed in favor of the judgment. As to the sufficiency challenge to the capacity issue, first of all, again, this is an appeal of a jury trial, so all those presumptions, all those deferences to the jury's fact finding and their credibility determinations must be applied. And the first step of the sufficiency argument is that there's no evidence. They have to show that there's no evidence to support the finding that Carlos lacked capacity. But there is evidence. Letitia testified that Carlos had capacity, and this wasn't a conclusory statement, oh, Carlos had capacity. She set forth the factual reasons for him having capacity. He could recognize her, he could recognize friends, he could recognize his doctors, he could have a conversation, he could eat by himself, all of those things. And Dr. Kant too, even though his testimony was kind of conflicting, he also testified that, he believed that Carlos Benavides could understand what was going on, and he had to understand the effects of the business in which he was transacting. So there is some evidence in the record to support the finding. But even if there were no evidence in the record, they have to show they have to conclusively establish that the evidence only leads to one conclusion, that he lacked capacity. And all they have is these testimony to these doctors. And each one of the doctors, Dr. Ticknor, Dr. Martinez, and Dr. Delaney, all had conflicting issues with their testimony. They all, Dr. Ticknor and Dr. Martinez relied on Dr. Marin's supposed finding that Carlos Benavides had mild to moderate dementia in 2005, when Dr. Marin never made that finding. He guessed after the fact. So they were mistaken. They relied on records they didn't have. They didn't know who prepared the records they relied on. And of course, regardless of all that, the jury, as the ultimate fact finder and the judges of the witnesses' credibility, could have just disbelieved these witnesses for whatever reason, that they had a bias, that they were hired guns, or that they weren't credible, or any of those reasons. And we have to defer to the jury's findings on that issue. So we have, in this case, at best, conflicting evidence about Carlos's capacity. That's not conclusive evidence. So the capacity finding has to be affirmed. And again, what the capacity finding in the judgment essentially says is they didn't prove their case. They didn't prove their defense. And that's all that matters. Now, going to the gift issue, they also challenged the sufficiency of the gift issue. Again, this is an appeal of a jury trial. All the presumptions and deferences have to be applied. So the first question is there any evidence in the record to support that Carlos Benavides made a gift of the O'Meara Circle residence house? And there is. We have Carlos's statement that lo total es mío es tuyo. All that I have is yours. He made that statement repeatedly. Ms. Hastings, the witness that Alexander brought in to tell the jury that Letitia did very bad things to Carlos, she testified that Carlos told her that he was going to give Letitia a house and a car. And more important, we have all the corroborating evidence after the fact. He put her on joint bank accounts. Carlos deeded her the office on Hidalgo Street. Carlos and Letitia did investments together. Carlos and Letitia did a deed of trust and refinanced the mortgage. Those are all the evidence that corroborate the Carlos's statement that he gifted the house to Letitia. And I think that's all that matters. Their defense is, well, we have these marital property agreements. And the evidence on that, as you may imagine, after a 3-week jury trial, the evidence on that was itself disputed as to whether or not that agreement even existed. We had conflicting testimony about when the agreement was. Yes, Shauna?
Let's assume the first agreement did not exist, but we have a ratification, the second ratification. Isn't that sufficient?
Well, in this case, no, for a couple of reasons.
Why not?
One, ratification is a fact question. There was no jury question on ratification. And in this instance, the issue of ratification was disputed. And for ratification, Alexander had to show that at the time Letitia allegedly ratified the premarital agreement, that she had full knowledge of all the terms of the premarital agreement, all knowledge of what's in that agreement at the time she ratified. You can't ratify something if you don't have complete knowledge of the thing you're ratifying.
But
And
I mean,
this,
with the recitals, she signed that she did essentially have complete knowledge, right? She said she completely understood those provisions. So how do you reconcile that?
sure, but in the testimony in the trial was undisputed that she didn't see the premarital agreement to 8 years later. And again, the evidence is conflicting on that. I agree with that. There's conflicting evidence. And whether or not Ms. Benavides' theory holds water or not, that's a question for the jury to decide. But based on what's in the record, she didn't see the premarital agreement until 8 years later. She didn't have even the premarital agreements missing the schedule, missing the pages listing the property. I believe it's section 11. So she could not have had full and complete knowledge of what was in that premarital agreement. Therefore, the ratification is ineffective. And to say that otherwise, alternatively, they had to have a jury question on it. They didn't request one. And then, yes, Your Honor.
Let me just play a little bit of devil's advocate. Okay, so they didn't request a jury question. There was no objection or anything. But if it's still a fact issue, if it's still controverted, shouldn't you get a finding of fact from the judge? And I know this is not a bench trial, no, it's a jury trial, but, shouldn't you have in some way preserved that issue? And I don't know the answer to it. I'm just kind of asking.
Well, I think the easiest answer to that is if a ratification here would be their affirmative defense or a counter defense, and they would have the burden of proof to request a question under Rule 279, and their failure to request any question on that results in a waiver unless it's conclusively established by the evidence. And as we mentioned, the evidence on this was far from conclusive. It was conflicting. Now, is the evidence, did it preponderate one way or the other? That's a question for the jury. And finally, I want to talk about the fraud and breach of fiduciary duty. We assert that needs to be affirmed as well. And the first issue we want to talk about is that there was a summary judgment granted in favor of the attorneys on the fraud, on the civil conspiracy, the knowing participation of breach of fiduciary duty. And that's not really fully set forth or clearly set forth in the brief. But let's start with the judgment. The judgment at Clerk's Record 1085 and 1084 and 1085. 1084, the judgment recites the summary judgment was granted on the money had received claim and the theft claim against the attorneys. And that summary judgment was based on limitations. But there was a second traditional and no evidence motion for summary judgment. It's evidenced by Alexander's response at the supplemental clerk record 778 to 838 and 839 to 899, where they responded to the traditional no evidence motion for summary judgment on the fraud, conspiracy, and knowing participation or breach of fiduciary duty claims. And Mr. Castillo filed a reply that's in the record, the supplemental record at 1026 to 1114. So what we had here is fraud claims, conspiracy claims, and breach of fiduciary duty claims asserted against both Letitia and the attorneys. The same claims, the same allegations. They were, the pleading asserted they acted together in concert. That was conspiracy. So the summary judgment in favor of the attorneys necessarily bars those same claims against Letitia. And it just makes sense. The other issue there, before I make sure I fully open, is there's nothing in the record that ties there's nothing in the jury charge that ties their damages to their fraud and breach of fiduciary duty questions. The fraud and breach of fiduciary duty questions that were proposed, submitted to the jury, were the generic, general pattern PJC questions. And they answered yes to both those questions. The jury did. The damages questions were more specific, in asking what were the amount of the attorney fees paid. But if you look at the closing argument, Alexander made numerous arguments about fraud and breach of fiduciary duty. She asserted that Letitia hid documents, that Letitia failed to disclose information, Letitia did fake loans, that she siphoned off $800,000 of money. So it's entirely possible that the jury could have said one of those other things was fraud, but not the attorney fee check. That's why they answered zero. I see my time is up.
Thank you, Mr. Reagan. The Appellee's counsel may proceed. Ms. Blakeway.
May it please the court. The appellee is asking the court to do four things. First, award the award to the accounts to the guardian be affirmed. Second, that the judgment be reformed to delete the declaration that C.Y. Benavides Jr. did not lack capacity from August 2011 to January 2013. Third, that Letitia Benavides take nothing on her claim to the house at O'Meara Circle. And fourth, that Christina Alexander, as the guardian, recover $73,512 from Letitia Benavides. Let me address the account issue first. The judgment awarding the accounts to the guardian should be affirmed. The guardian's pleadings in this interpleader support the award of that. As the court has already noticed, Mathis pled, quote, for a judgment, quote, decreeing Carlos Y. Benavides Jr. to be the owner of all funds interpled by the financial institutions. When Alexander became the successor guardian, she succeeded to that pleading. When you have a new guardian, you don't start over again after 2 years of litigation and go back to square one. She succeeded to that pleading. Now, that is a sufficient pleading in a guardianship. And remember what Letitia's theory of the case was that Carlos gave her everything he owned. Todo lo mío es tuyo. That theory necessarily assumes that he owned those accounts because you cannot give away what you do not own. So it was inconsistent for her theory to not claim that or not to concede that he owned those. Secondly, the trial court correctly awarded possession and control of the accounts to the guardian. The jury found that Carlos contributed 100% of those funds and refused to find that he made her a gift of any account. So under the estates code, those accounts belonged to Carlos, not to Letitia. And under the estates code, the guardian has the absolute right to possess and control the funds of the ward. So the court was correct when he had a jury finding that Carlos owned those to say that in accordance with exactly what the estates code says, which says, quote, the guardian of the estate of a ward is entitled to possess and manage all property belonging to the ward. So that judgment was consistent with the jury finding. And since this was an interpleader, in an interpleader, what happens is the bank, which has the accounts, says, I have competing claims to these accounts. I don't have a dog in this fight. I dump the money into the registry of the court. You two guys fight it out and you determine who is entitled to these accounts. That's
Let me
exactly.
ask you a question if I can.
Sure.
Was the date of the gift, is the date of a gift an essential element of the lack of capacity defense?
No, but it is key to understanding what happened here, because the date of the gift is undisputed, is 2004. The recital in the judgment is 2011 to 2013. So the only date that is important is the date of the only gift found by the jury. There was only one gift, and that was the house. And Letitia testified that the date of that gift was 2004. And when you had the charge conference, the trial judge asked, what date should I put in here? And Letitia's counsel said, oh, judge, no need to put any date in because the date of the gift is September 14th, 2004. So there is no jury finding, contrary to what appellant's counsel argued. There is no jury finding about the gift being in 2011 or 2013. The undisputed date of the gift is 2004. And there was no argument that Carlos was incapacitated in 2004. Where that recital came from is because Letitia slipped it into her proposed judgment to the court. There was no jury finding to support it. And the reason she did that is because in the guardianship case, she was precluded from participating because she was adverse to the guardian. And the guardianship court had found that Carlos was incapacitated, because you can't appoint a guardian for somebody who's not incapacitated. And she's precluded from challenging that finding by, among other things, an opinion from this court that said she was adverse, and therefore, under the estates code, she lacked standing to contest the appointment of a guardian or to contest who the guardian was. And because of that, she's trying to do an end run around that judgment in an interpleader. She can't do that. And honestly,
What is if I may follow up, what's the harm? Because part of your relief is wanting to reform the judgment regarding the declaration of his lack of capacity. What's the harm by the inclusion of a written finding?
Oh, exactly. I'm sorry, go ahead.
That he lacked capacity.
Well, he's told you what he intends to do with that finding. There's Mr. Carlos is deceased now.
Well, not the consequence of it and whether it's a benefit or a disadvantage to someone else, but what's the harm of including it as a finding in the judgment?
The harm is that
to the appellees.
That because he intends to take that finding over to the probate court and say that Carlos was incapacitated during that period of time. And she intends to use that finding to contradict the guardianship finding that Carlos needed a guardian during that time. So he's creating a conflict. There is no conflict right now, but he's creating a conflict because he wants to use it in the will contest. That's the harm. And why should there be that recital? The judge didn't find it. It's not supported by the evidence. The jury didn't find it. It was just, she slipped it in there so she could use it in another case. That's the harm. So she had no vested rights to the account before Carlos passed away anyway, because a right of survivorship doesn't give you an ownership interest in an account. It gives you a right that may or may not mature depending upon what happens from the time the account is open until the time that the person who gave you the survivorship is deceased. And so in this event, because Carlos divorced Letitia before her death, she had no claim to the rights under a right of survivorship anyway. Under the estates code, if a decedent establishes a multi-party account and the marriage is later dissolved by divorce, any provision in the survivorship agreement with respect to that account in favor of the former spouse is not effective. So in any event, she would not have an interest in those accounts by virtue of having the right of survivorship. And that rebuts his argument that it's a personal right that no one can do anything about. It's not, because the estates code specifically says a person on a multi-party account has the right to take somebody off the account. And it defines party to include a guardian. And therefore, a guardian has a right to remove somebody from the account or a right to delete revoke the survivorship designation, which is exactly what Shirley Mathis did in this case. So back to the issue about the recital in the judgment that he lacked capacity. There is no jury finding to that effect because the jury was told how capacity came up. It was an affirmative defense by the guardian to his claim of gift. And so the guardian argued he didn't have capacity to make a gift. The jury found against the guardian on that. And we're not contesting that. But what we're saying is a jury's finding of no is not an affirmative finding. And the jury was instructed, you need to answer this by preponderance of the evidence. If you can't answer yes by preponderance of the evidence, answer no. So first, there is no jury finding to support it. And then secondly, he says, oh, well, it's cured because Carlos made a gift of the house. He says, after being instructed that that gift requires knowledge or consent of improvements. That doesn't cure it because knowledge or consent is not capacity. My daughter is doing renovations to her house right now. She has a 5-year-old child. The 5-year-old child has knowledge that they're doing improvements. He can see the carpenter, he can see the electrician, he can hear the plumber. So he knows that. But does he have capacity? No, he doesn't have capacity because he's 5 years old. Likewise, Carlos didn't have capacity. The medical testimony in the case was he had the mental capacity of a 2-year-old. So the finding that he had knowledge or consent, either one, is not a finding of capacity. Likewise, the guardian did not waive her objection to the judgment by failing to request a specific date in question number 2, because I said it was undisputed. Even the judge asked her attorneys, should we put a date in there? And they said, oh no, it's 2004. And then his argument about you don't have a gift until you make the improvements. That's just incorrect. We cite a case in there where the jury found the gift was, there was evidence the gift was made in 1962. There were improvements in 1964. The jury found that gift was made in 64. Court of Appeals reversed because it's like, look, you can only make a gift one time. You can't make a gift over and over. Once you gave it away, you don't have it to give away anymore. And so the improvements, the judge even asked this when he in the charge conference, what if they do improvements 20 years later? Their gift wasn't made until 20 years later? No. In an equitable proceeding, which is an oral gift to get around the statute of frauds, the improvements serve 2 purposes. One is an evidentiary purpose. You don't make improvements to other people's property. So the fact that you made substantial and valuable improvements is evidence corroborating the gift. But the other reason is it's an equitable remedy. And if you make a lot of substantial and permanent valuable improvements to somebody else's property, it might not be right to make you give it back if you made them under a misunderstanding that you had the property. But there's only one date of the gift. And here that undisputed date was in 2004, not 2011 to 2013. There is no evidence to support the recital that Carlos did not lack capacity from August 2011 to January 2013. There was 0 expert testimony that Carlos did not lack capacity during that period of time. Dr. Cantu recanted his testimony about Carlos's capacity. He later admitted he didn't have it. Dr. Coulter's reports were from 2005 to 2009, not from 2011 to 2013. The only witness who testified that Carlos did not lack capacity was Letitia. And as pointed out in our opening brief, her testimony was incompetent. Now they say, oh, a lay witness can testify. That's true if it's knowledge within the knowledge of a lay witness, but dementia is not within the knowledge of a lay witness. That requires medical testimony. And capacity is not within knowledge of a lay witness. That requires a legal opinion. And that is why all those cases hold that somebody can't come in a will contest. A lay person can't come in and testify about capacity. Same thing here. A lay witness is not qualified to talk about capacity. And then the court's declaration that Carlos did not have capacity from 2011 to 2013 is inconsistent with previous judgments denying Letitia standing. And those judgments are in the guardianship case where the court appointed a permanent guardian. Actually, the court appointed a temporary guardian, which under the estates code, you cannot do unless you find substantial evidence of incapacity. So she can't circumvent the judgment that she lacks standing to litigate Carlos's capacity by collaterally attack it in an interpleader action. That is what she's doing. The court order appointing the permanent guardian in the guardianship case found that Carlos was incapacitated when he signed estate planning documents on September 24th, 2011. And that finding, she says, well, I'm not bound by it because I wasn't a party to the guardianship. Well, she is bound by it. And the reason she's bound by it is because she lacks standing to contest that finding. And therefore, even though she's not a party, she can't contest that finding. Then she says, well, standing's not a decision on the merits. Well, that's true. It's usually not a decision on the merits, but in this case, it is a decision on the merits because she can't contest his need for a guardian. Turning to the gift of the house, the trial court erred in refusing to disregard the jury's finding that Carlos made an oral gift of the house. And that is because the premarital and property agreements preclude an oral gift. So the first thing that he has wrong about his argument about you didn't request an issue about it, so it's waived, is he's got the burden of proof backwards. The premarital and the property agreement are both in evidence. They're defendants 6 and 7. And since they're in evidence, they are presumed valid. When I sue somebody for breach of contract, I put the contract in evidence. That's evidence of what the contract says. I do not have to say, oh, by the way, you weren't drunk when you signed this, were you? Or were you over 18 years old? I don't have to go through and rebut every possible defense somebody might have to the contract. As soon as that contract's in evidence, it's presumed valid, and the burden of attacking the contract and showing that for some reason it's not valid is on the person contesting the contract. Second, he says, well, Alexander said you can make a gift. The guardian admitted you can make gifts. Well, that's true. She did say that. And under those agreements, you can make gifts, but they have to be in writing, signed by the parties. You can't make oral gifts. And that's what she's claiming here. And as the court's already pointed out, there is a judicial admission by Letitia that she signed the property agreement. The property agreement ratifies the premarital agreement. And now she says, oh, I couldn't ratify it because I didn't know anything about it. I have to know everything about it. So apparently it's maybe not so important that she didn't sign something as we thought, because even when she signs it, she says not bound by it. Even when she says, I know everything I recited, I'm waiving this. It's like, well, just kidding. She signed it. By signing it, she ratified the premarital. That's a judicial admission that she cannot contradict. Then he says, well, it is undisputed that she didn't see that premarital agreement until 8 years later. Actually, he said 3, but it was 8. when she gave her deposition. But that argument is belied by the record. He said it was undisputed. It is not undisputed. If you look in the record, first thing that's in there is the premarital agreement, Defendant's Exhibit 6, and the property agreement, Defendant's Exhibit 7. If you look at those, she said she never signed the premarital agreement. So you would expect to see a blank signature, but that's not what you see. You don't see a place for Letitia's signature and there's no signature there. You see her signature. And furthermore, you see her initials on every single page. If you compare Defendant's Exhibit 6 to Defendant's Exhibit 7, which admittedly she signed, so there's her handwriting exemplar, they are the same. Did Letitia ever claim a forgery that somebody else signed her name? No, she never did. She says it wasn't signed. Well, it looks like it's signed. But if that's not enough for you, it's notarized. And the notary came to testify. Maria Santos testified. And she testified, yes, that is my notary stamp. Yes, that is my signature. And no, I would not have notarized that if she did not appear before me. So we have that testimony. If that's not enough, you have the testimony of Miss Hastings. Miss Hastings says that she went by to see Letitia the night before the wedding because Letitia wanted to see the flowers. And then Letitia said, I need to go by the office and pick up some papers. It was very late. It was 11:30. So Miss Hastings says, I will go with you. So as she says, this is on 22 Reporter's Record, page 218. I was just there so she wouldn't be by herself. And I heard her scream. She kind of cursed. She said a curse word. Question, what did she say? Answer, the F word. She kind of screamed it. Question, okay, and what else? Answer, she went to where the fax machine was, and that's when she said the curse word, and she screamed because it was papers. Question, what did she say? Or what did you see or hear at that point? Question, she said, it's the prenup papers. Question, prenup papers? Answer, yes. Question, what else did she say? Answer, she picked them up off the floor and later said it didn't matter because he could gift her while he was alive. Question, what else did she say? Answer, that she wasn't going to worry about it because whatever he had, he could gift it to her while he was alive. And then on page 23, Reporter's Record, page 15, it says, question, in your testimony, you told us that in the machine, there were 20 or more than 20 pages. Answer, yes. Question that came in, how do you know there were 20 pages? Answer, because Letty told me. Question, what did she tell you? She said, F this, the effing prenuptial agreement, and it's some 20 odd pages. If that weren't enough, we have the testimony of an invoice from Letitia's attorney, Armando Lopez, who represented her in connection with the prenup and property agreements, and asking her, this is at 10 Reporter's Record 235, about that, the bill that her attorney sent her for reviewing those agreements for her. Question, and then his notation on his invoice says, receipt and review of premarital agreement, waiver of disclosure, property agreement, client conference to review same, and email to John Compere with minor revisions, correct? Answer, yes. John Compere was the attorney who represented Carlos Benavides in connection with those. And then we have John Compere's records. And his, unfortunately, at the time of trial, John Compere had passed away, but his paralegal, Barbara Laval, came and she testified. It's at 23 Reporter's Record 43 to 44 and 23 Reporter's Record 79 and 80. She testified that she had fully executed copies of the premarital agreement and the property agreement, and she recognized the signatures of both Letitia Benavides and Carlos Benavides. So it is far from undisputed that she never saw that premarital agreement. And then Ms. Alexander's testimony, of course, that yes, he could make gifts was perfectly correct because he could, but they had to be in writing and signed by the parties. In any event, there was no need for a jury issue about the premarital agreements anyway, because it wasn't an ultimate issue in the case. The ultimate issue in the case was, did he make gifts? And if so, what did he give? And in this case, the jury found against him on every single thing except for the house. The
Counsel,
problem.
may I interrupt you? So
Sure.
Since we're talking about the gift of the house, I'm looking at page 1087 and 1088 of the court's final judgment. So let's just assume, for argument's sake, that we agree with you that the combination of the premarital agreement and the postmarital property agreement precludes an oral gift of real property. So that first, it is ordered, adjudged, and decreed paragraph on page 1087. Just assume for argument's sake, we would reverse that. What would, and I guess that means just logically, we would have to also vacate the next paragraph, which says that the parole gift of the residential property, basically was not made through the lack of mental capacity. You've raised both of those arguments, but you haven't challenged the final paragraph on page 1087 that goes on to 1088, which talks about undue influence. If we agree with you on the legal operation of the premarital agreement and the postnuptial property agreement, what do we do with that last paragraph on 1087 that bleeds onto the top of 1088?
I don't think we need an undue influence finding, or we don't attack that finding. We don't attack that issue. And the reason for it is if you don't have capacity, you can't be unduly influenced. I mean, capacity is, or undue influence is when I have the ability to decide things, but I am unduly influenced by somebody else, but I still have, it's not that I lack capacity. It is that, say, I am dependent upon my spouse for care. And I know if I don't do what she wants, it's like, she's not going to take me to the bathroom, and she's not going to feed me, and she's going to be mad at me, and my life is going to be miserable. So I do what she wants. It's not like I don't know any better, or it's my will is overcome by her will, so that when I'm doing something, it's her will. But we did not, in our appeal, we did not challenge the jury's failure to find on our defense of undue influence.
Thank you.
So back to the gift of the house. Letitia has a statute of frauds problem because she doesn't have anything in writing. She concedes that. We don't have a writing that would satisfy the statute of frauds, and this is real property. So what to do? She says, well, it was an oral gift. And you can have an oral gift of real property, but it's not easy because they're disfavored. That's why we require it to be in writing, because to prevent fraud, if you're going to transfer real property, it's got to be in writing and it's got to be signed by the party to be charged. But there's exceptions, and here they're relying on one. So here are the three elements they have to prove. They have to prove a gift in presente at the present time. They have to show possession under the gift, like delivery, if it's personal property. And three, they have to show permanent and valuable improvements. They did not prove a single one. And they don't have to, they have to prove all three. So if they have a failure of even one, then they have not met their burden of showing an oral gift. So first, present donative intent. They rely on three things. They rely on Ms. Hastings' testimony that Carlos was going to give Letitia a house and a vehicle in the prenup. Of course, testimony that somebody is going to do something in the future is no evidence that they have a present intent and did it with a present intent. Second, they say Letitia's testimony that Carlos told her, todo lo mío es tuyo, all that I have is yours. That is no evidence either, because it is one of those sayings that is not intended to be taken literally. It is an ordinary, reasonable, prudent person would not understand that when my spouse told me, honey, I love you, everything I have is yours. Thank you, dear. You just gave me everything you own. No reasonable person would understand that. And I guarantee you, my husband would be really surprised if I told him, thank you, I now own everything, the house, the cars, you can have the kids. But that is just too frail a read. I mean, it's like the example I give at the bridegroom who tells his bride, with all my worldly goods I thee endow. Do you think a bride would be reasonable thinking, great, now my husband has nothing? Or the prodigal son, the elder son is complaining. Father says, son, everything I have is yours, but your brother who was lost is found. We must celebrate. Do you think he made a present gift of everything to the elder son, so the younger son was unfortunately now penniless again? Or suppose this example. Suppose it's during the February storm and I have no power in my house. I have no electricity, I have no gas, I have no water, I have nothing. And I'm complaining to you. And you, being a very generous and kind person, say, Judy, you can come stay with us until your power goes back on. And so I go stay with you and I'm thanking you for being so kind. And you are gracious and you say, mi casa es su casa, my house is yours. Great, you just gave me your house. Do you think you would understand that? Do you think I would be reasonable to understand that you just made a gift to me of your house? No. That testimony that he relies upon for the gift is the same type of thing. And then, so it's no evidence of a present intent to divest himself of title in favor of Letitia. Likewise, the final thing he argues is, well, they refinanced the house. And when they refinanced the house, they gave a deed of trust to the bank and it's got Letitia's name on there as a borrower. So what? That affects the legal relationship between her and the bank, but it doesn't affect the legal relationship between her and Carlos. If it's probative that Letitia had title, then it is equally probative that Carlos had title because he's on there. It's certainly no evidence that he had a present intent to divest himself of title in favor of Letitia. In short, there is no evidence of present intent. So the jury's answer to question number 1 should be disregarded. Then there is no evidence of the second requirement, which is the possession under the gift. Letitia and Carlos lived in the house before they got married. They lived in the house after they got married. And he argues, well, they lived together. She moved into the house. That shows that she was in possession. Most married people do live together, but that's no intent, doesn't evidence an intent that one intended to give the house to the other one. So there is no evidence of delivery. There's no evidence of a present gift. And finally, there is no evidence of the third requirement that she made valuable improvements to the property at her own expense. It's clear she did make improvements. She spent $56,863, but she refused to be responsible for the cost of those improvements. She submitted the bill to the guardian, said the guardian should pay. And therefore, that evidence is evidence that she thought she didn't own the house because you don't ask somebody else to pay for permanent and valuable improvements to your property. So lack of any evidence of any of those elements of an oral gift is sufficient to defeat her claim to the house, and she lacks evidence of each of them. Therefore, the jury's answer to question number 1 should be disregarded.
Thank you, counsel. If you want to just close with a sentence or two, so
Sure,
we can go on rebuttal. Thank you.
Thank you. I'd just like to say one thing about the $73,000. There is, the reason it's tied is because of the jury instructions that limits what the jury can consider for damages. Finally, my prayer for relief is that the court should affirm the award of the accounts to the house, to the guardian. The judgment should be reformed to delete that declaration that he lacked capacity from August 2011 to January 2013. The judgment should be reformed. She takes nothing on her claim of an oral gift of the real property. And the Alexander, the guardian, should recover from Letitia $73,512.
Thank you, counsel.
May it please the court. Going in the order which the Mrs. Blakeway's, my friend's argument. First, I believe Justice Martinez asked, did Alexander have any pleadings to support the declaratory judgment finding by the court? And she quoted the part from Mrs. Mathis's pleading where she asked for a judgment declaring that she had ownership of the interpleaded funds. What Ms. Blakeway didn't tell you was, or point to, was any pleading where Mathis, Alexander, or anyone else asked for possession and control of the funds. There is no pleading to support that. Number 2, there was a question about whether the date of the gift is an essential element of the claim. And Ms. Blakeway said no, but the Texas Supreme Court says otherwise. Whether or not Mr. Benavides had capacity to do an act must be determined on the date he did the act. And here we have the day of the gift, which is undisputed, is 2004. But the gift was not complete until she made the valuable improvements with Mr. Benavides' knowledge and consent. So it's a two-part question. That is the Hooks case from 100 years ago from the Texas Supreme Court. The gift is not complete until the donee makes valuable improvements with the knowledge and consent of the donor. And whether or not it's essential element, of course it is. It's in question 1 of the jury charge. As to real property, permanent and valuable improvements made on the property by the donee with the donor's knowledge or consent is required. And their theory is he didn't have capacity to know about the improvements or to consent to the improvements. Well, then again, we're back to our issue. That was their burden of proof to get that finding from the jury. They didn't request it, and they have waived it. The bigger issue I have is Alexander's continued reliance on the guardianship finding that Carlos lacked capacity. I believe it was called in the briefing and argument today that we're trying to make an end run on the guardianship finding that Carlos lacked capacity. That cannot be the case here. That is a res judicata collateral estoppel argument. I believe Alexander had a collateral estoppel parenthetical in support of this argument in her brief. What they're arguing is they come to court in the 49th District Court and say, you lose, Ms. Benavides, because Carlos lacked capacity. And you lose because we got this finding from the other court. Well, Ms. Benavides wasn't a party to that case. She didn't get to present her evidence in that case. It offends notions of due process to say she loses this case because some other court found that Carlos lacked capacity in which she was not a party to that case. And she's asserting claims in this case. Of course, she has standing to challenge their affirmative defensive capacity. That's why we're here. The next thing was about the gifts, the Patterson case, where the gifts could be made 20 years later. Those are all fact issues for the jury to determine. Again, is hanging a pair of mini blinds a valuable and permanent improvement? Or is it, doing some plants, or is it a complete renovation of the house? The jury gets to determine whether or not those improvements were valuable and permanent. And when the jury gets to determine when that date that those improvements were made. And then their defense is he didn't have capacity on the date those valuable improvements were made. Again,
let me ask you a question, if I may.
Sure.
If on review we find that the trial court erred in including the date due, does the appellate court have authority to simply reform the judgment, or do we have to remand it back to the trial court to determine any date?
I'm not sure, but I would assume that the appellate court has the authority to reform the judgment, to change it to say merely Alexander failed to plead her capacity defense. And that's essentially what the jury found, and that's what they're arguing about. Yes.
Thank you, Mr. Reagan. Mr. Reagan, I've got a question with regards to the issue of Leticia's standing or lack of standing. Are you, with respect to the lack of standing respect to the lack of standing that she has in this cause of action, this interpleader cause of action, are you saying that she does have standing in this action and it's limited to the issues presented in this action? Or are you saying she has standing to attack the capacity or incapacity in any type of forum?
What we're arguing is we presented claims that there was a gift. The defense is he's incapacitated and we have a finding from some other court. Our argument is that other judgment finding he lacked capacity is not binding on us, or it's not binding on the trial court. It's not binding on this court because we were not a party to that case and we didn't have an opportunity. So it's no res judicata or collateral estoppel or anything like that.
Okay, and so then I'm right that you are just limiting the issue of that she can attack the capacity or incapacity issue, but limited to the issues in this case.
Well, I think it would be limited to the issues of the case because that was the controversy. Yes.
Okay, thank you. In other words, you're not going to use it like they said in another case.
Well, that is incorrect. They
Okay.
had so they put an affirmative defense up that he lacked capacity, and they tried that issue. They presented expert testimony saying he lacked capacity starting in 2005, 2006. Dr. Tignor went from 2010, the guardianship case, to beforehand. They've tried the capacity issue. They had the burden on it. They tried it. They lost. And if there's any other consequences down the road, they should have to live with it. They lost. And we shouldn't have to go through the expense of another 3 to 4 week jury trial to litigate all the same issues again, if there is one. That's why I think the judgment's perfectly fine. But if it needs to be reformed to say Alexander failed to prove her capacity defense through the relevant time period, that's fine too. We get it's 6 inches one way and half a foot the other way.
And I understand that you want to limit it to this case, but what I'm seeing is an issue was raised by Ms. Blakeway saying that because of that finding, they would have an issue preclusion in subsequent litigation. And that's not right because she didn't have standing to begin with. Maybe I'm...
I didn't get that one.
Okay. Okay, but it's limited to this case and you should not be precluded from raising it in other cases, and that's your position, correct?
Yes, we should not be precluded from raising their failure to plead their capacity defense in this, that they failed to prove in this case.
Thank you, Mr. Reagan. Sorry about that, the confusion.
No, I'm here to help you. Thank you. The other issue about the premarital contract, Ms. Blakeway said something quite remarkable, that once the contracts and evidence, it's presumed valid, and that's the end of the story. I didn't see any authority for that. I've tried quite a few cases, quite a few breach of contract cases. Most of the time, the contracts and evidence, and most of the time, there's a question one, the jury charge was, did the parties agree to do X, Y, and Z? Just because the contracts and evidence doesn't mean that the contract is valid as a matter of law for all purposes. There's no authority for that. As to about the, yes, Your Honor?
But she didn't say that the contract was valid. She said the contract is presumed valid, and then the burden shifted to you. Assuming that she's correct, do you have an answer for that?
I don't believe the contract is presumed to be valid just because it's in evidence. There's that question one of the jury charge, PJC 101.1 is, did the parties agree? Is there the existence of an agreement? Did the parties agree to do X, Y, and Z? And they would have probably some evidence there, but they didn't ask for that question. They didn't ask for the existence of the agreement. And if they had asked for the existence of the premarital agreement or the postmarital agreement, then yes, the burden would have shifted to us to say unconscionability or involuntariness or duress or fraud, whatever the family code provides. As for the gifts, the lack of writing, we believe there is a writing. The deed of trust is some evidence of a writing. That deed of trust, as a matter of Texas law for years and years and years, is that Letitia had some legal title to the property. The deed of trust severs the title, the legal and equitable title. That's the red flag or red fern case that we cite in our brief. The ratification, Ms. Blakeway argued that was conclusive, but the notary book was missing the premarital agreement. The notary didn't remember them coming in to sign the premarital agreement. Ms. Hastings' testimony as to when it was signed, she said Carlos told her she signed it on Friday. The agreement was purportedly signed on Saturday is conflicting. And what was not mentioned is at the time it was allegedly notarized, Ms. Benavides was getting ready for her wedding. So that conflicting evidence raises a fact issue for the court.
I'll give you 60 seconds to close as well.
Yes, I want to finish the last thing Ms. Blakeway was talking about, the mi casa su casa argument. She mentioned that an ordinary reasonable person would not have believed that Mr. Benavides was being literal or Mr. Benavides was being serious. Ordinary, reasonable, that rings of a fact question. That's something for the jury to determine. What was his intent? If you look at all of our fraud cases, intent has to be determined by what the subjective state of mind of the person making the statement. Here, Mr. Benavides not only said, I give you everything, and whether he meant literal or not, or whether he meant to the house or to the property, but the jury found that he did mean it literally with regard to the house. And the evidence of a gift was corroborated by all the other things we talked about: the bank accounts, the cars, the investments, the deed to the Hidalgo property, the deed of trust. All those things corroborate his gift in this case. So yes, it was for a jury to determine whether was it reasonable and ordinary for Mr. Benavides to give the gift the way he did. The jury resolved those fact issues in our favor, and that fact issue must stand. And if there are no other questions, I'll conclude my argument.
Thank you, counsel. The case is now submitted, and of an opinion is forthcoming. And so counsel is excused and court is in recess.